October term, 1985. Syllabus 478 U.S. Bowers, Attorney General of Georgia v. Hardwick et al. Certiorari to the United States Court of Appeals for the 11th Circuit. No. 85 to 140. Argued March 31, 1986. Decided June 30, 1986. After being charged with violating the Georgia statute criminalizing sodomy by committing that act with another adult male in the bedroom of his home, respondent Hardwick brought suit in federal district court, challenging the constitutionality of the statute insofar as it criminalized consensual sodomy. The court granted the defendant's motion to dismiss for failure to state a claim. The Court of Appeals reversed and remanded, holding that the Georgia statute violated respondent's fundamental rights. Held, the Georgia statute is constitutional. pp. 190 to 196. The Constitution does not confer a fundamental right upon homosexuals to engage in sodomy. None of the fundamental rights announced in this court's prior cases involving family relationships, marriage, or procreation bear any resemblance to the right asserted in this case. And any claim that those cases stand for the proposition that any kind of private sexual conduct between consenting adults is constitutionally insulated from state proscription is unsupportable. pp. 190 to 191. Against a background in which many states have criminalized sodomy and still do, to claim that a right to engage in such conduct is deeply rooted in this nation's history and tradition or implicit in the concept of ordered liberty is, at best, facetious. pp. 191 to 194. There should be great resistance to expand the reach of the due process clauses to cover new fundamental rights. Otherwise, the judiciary necessarily would take upon itself further authority to govern the country without constitutional authority. The claimed right in this case falls far short of overcoming this resistance. pp. 194 to 195. The fact that homosexual conduct occurs in the privacy of the home does not affect the result. Stanley v. Georgia, 394 U.S. 557, distinguished. pp. 195 to 196. Sodomy laws should not be invalidated on the asserted basis that majority belief that sodomy is immoral is an inadequate rationale to support the laws. p. 196. 760 F2D 1202, reversed. Bowers v. Hardwick. 186. Opinion of the Court. J. Delivered the opinion of the Court, in which Berger, C.J., Powell, Rehnquist, and O'Connor, J.J. C.J., Post, p. 196, and Powell, J., Post, p. 197, filed concurring opinions. J. filed a dissenting opinion, in which Brennan, and Stevens, J.J., joined, Post, p. 199. J. opinion, in which and Marshall, J.J., joined, Post. Michael E. Hobbs, Senior Assistant Attorney General of Georgia, argued the cause for petitioner. With him on the briefs were Michael J. Bowers, Attorney General, Pro Se, Marion Zero. Gordon, First Assistant Attorney General, and Darrell A. Robinson, Senior Assistant Attorney General. Lawrence H. Tribe argued the cause for respondent Hardwick. With him on the brief were Kathleen M. Sullivan and Kathleen L. Wild ***. Justice White delivered the opinion of the court. In August 1982, respondent Hardwick was charged with violating the Georgia statute crimi. Briefs of amici curiae urging reversal were filed for the Catholic League for Religious and Civil Rights by Stephen Frederick McDowell, for the Rutherford Institute et al. By W. Charles Bundren, Guy Zero. Farley, J.R., George M. Weaver, William B. Hallberg, Wendell R. Bird, John W. Whitehead, Thomas Zero. Kotuk, and Alfred Lind, and for David Robinson, J.R., Pro Se. Briefs of amici curiae urging affirmance were filed for the State of New York et al. By Robert Abrams, Attorney General of New York, Robert Herman, Solicitor General, Lawrence S. Kahn, Howard L. Zwickel, Charles R. Fraser, and Sanford M. Cohen, Assistant Attorneys General, and John Van de Kamp, Attorney General of California. For the American Jewish Congress by Daniel D. Levinson, David Cohen, and Frederick Mondell, for the American Psychological Association, penalizing sodomy by committing that act with another adult male in the bedroom of respondent's home. After a preliminary hearing, the district attorney decided not to present the matter to the grand jury unless further evidence developed. Respondent then brought suit in the federal district court, challenging the constitutionality of the statute insofar as it criminalized consensual sodomy. He asserted that he was a practicing homosexual, that the Georgia sodomy statute, as administered by the defendants, placed him in imminent danger of arrest, and that the statute for several reasons violates the federal constitution. The district court granted the defendant's motion to dismiss for failure to state a claim, relying on Doe v. Commonwealth's attorney for the City of Richmond, 403 F. Sup. 1199, which this court summarily affirmed, 425 U.S. 901. Georgia Code N 16-6-2 provides, in pertinent part, as follows. A person commits the offense of sodomy when he performs or submits to any sexual act involving the sex organs of one person and the mouth or anus of another. A person convicted of the offense of sodomy shall be punished by imprisonment for not less than 1 nor more than 20 years, and Mary Doe were also plaintiffs in the action. They alleged that they wished to engage in sexual activity proscribed by 16-6-2 in the privacy of their home, App. 3, and that they had been chilled and deterred from engaging in such activity by both the existence of the statute and Hardwick's arrest. ID. At 5. The district court held, however, that because they had neither sustained, nor were in immediate danger of sustaining, any direct injury from the enforcement of the statute, they did not have proper standing to maintain the action. ID. At 18. The Court of Appeals affirmed the district court's judgment dismissing the Doe's claim for lack of standing, 760 F2D 1202, 1206-1207, and the Doe's do not challenge that holding in this court. The only claim properly before the court, therefore, is Hardwick's challenge to the Georgia statute as applied to consensual homosexual sodomy. We express no opinion on the constitutionality of the Georgia statute as applied to other acts of sodomy. Bowers v. Hardwick. 186. Opinion of the Court. A divided panel of the Court of Appeals for the 11th Circuit reversed. 760 F2D 1202. The court first held that, because Doe was distinguishable and in any event had been undermined by later decisions, our summary affirmance in that case did not require affirmance of the district court. Relying on our decisions in Griswold v. Connecticut, 381 U.S. 479, Eisenstadt v. Baird, 405 U.S. 438, Stanley v. Georgia, 394 U.S. 557, and Roe v. Wade, 410 U.S. 113. The court went on to hold that the Georgia statute violated respondent's fundamental rights because his homosexual activity is a private and intimate association that is beyond the reach of state regulation by reason of the 9th Amendment and the Due Process Clause of the 14th Amendment. The case was remanded for trial, at which, to prevail, the state would have to prove that the statute is supported by a compelling interest and is the most narrowly drawn means of achieving that end. Because other courts of appeals have arrived at judgments contrary to that of the 11th Circuit in this case, we granted the Attorney General's petition for certiorari questioning the holding that the sodomy statute violates the fundamental rights of homosexuals. We agree with petitioner that the Court of Appeals erred, and hence reverse its judgment. C. Baker v. Wade, 769 F2D 289, rehearing denied, 774 F2D 1285 Zec, 239 U.S. FDC 229, 741 F2D 1388, rehearing denied, 241 U.S. App. DC 262, 746 F2D 1579. The district court was not obligated to follow our summary affirmance in Doe. We need not resolve this dispute, for we prefer to give plenary consideration to the merits of this case rather than rely on our earlier action in Doe. C. Usury v. Turner Elkhorn Mining Co., 428 U.S. 1, 14, Massachusetts Board of Retirement v. Murgia, 427 U.S. 307, Edelman v. Jordan, 4, October term, 1985. Opinion of the Court. 478. This case does not require a judgment on whether laws against sodomy between consenting adults in general, or between homosexuals in particular, are wise or desirable. It raises no question about the right or propriety of state legislative decisions to repeal their laws that criminalize homosexual sodomy, or of state court decisions invalidating those laws on state constitutional grounds. The issue presented is whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time. The case also calls for some judgment about the limits of the court's role in carrying out its constitutional mandate. We first register our disagreement with the Court of Appeals and with respondent that the court's prior cases have construed the Constitution to confer a right of privacy that extends to homosexual sodomy and for all intents and purposes have decided this case. The reach of this line of cases was sketched in Carey v. Population Services International, 431 U.S. 678, 685. Pierce v. Society of Sisters, 268 U.S. 510, and Meyer v. Nebraska, 262 U.S. 390, were described as dealing with child rearing and education, Prince v. Massachusetts, 321 U.S. 158, with family relationships, Skinner v. Oklahoma ex rel. Williamson, 316 U.S. 535, with procreation, Loving v. Virginia, 388 U.S. 1, with marriage, Griswold v. Connecticut, supra, and Eisenstadt v. Baird, supra, with contraception, and Roe v. Wade, 410 U.S. 113, with abortion. The latter three cases were interpreted as construing the Due Process Clause of the 14th Amendment to confer a fundamental individual right to decide whether or not to beget or bear a child. Carey v. Population Services International, supra, at 688 to 689. Accepting the decisions in these cases and the above description of them, we think it evident that none of the rights announced in those cases bears any resemblance to the Bowers v. Hardwick claimed constitutional right of homosexuals to engage in acts of sodomy that is asserted in this case. No connection between family, marriage, or procreation on the one hand and homosexual activity on the other has been demonstrated, either by the Court of Appeals or by respondent. Moreover, any claim that these cases nevertheless stand for the proposition that any kind of private sexual conduct between consenting adults is constitutionally insulated from state proscription is unsupportable. Indeed, the court's opinion in Carey twice asserted that the privacy right, which the Griswold line of cases found to be one of the protections provided by the Due Process Clause, did not reach so far. 431 U.S., at 688, and 5, 694, and 17. Precedent aside, however, respondent would have us announce, as the Court of Appeals did, a fundamental right to engage in homosexual sodomy. This we are quite unwilling to do. It is true that despite the language of the due process clauses of the 5th and 14th Amendments, which appears to focus only on the processes by which life, liberty, or property is taken, the cases are legion in which those clauses have been interpreted to have substantive content, subsuming rights that to a great extent are immune from federal or state regulation or proscription. Among such cases are those recognizing rights that have little or no textual support in the constitutional language. Meyer, Prince, and Pierce fall in this category, as do the privacy cases from Griswold to Carey. Striving to assure itself and the public that announcing rights not readily identifiable in the Constitution's text involves much more than the imposition of the justice's own choice of values on the states and the federal government. The court has sought to identify the nature of the rights qualifying for heightened judicial protection. In Palco v. Connecticut, 302 U.S. 319, 325, 326, it was said that this category includes those fundamental liberties that are implicit in the concept of ordered liberty, such that neither October. The court. Liberty nor justice would exist if were sacrificed. A different description of fundamental liberties appeared in Moore v. East Cleveland, 431 U.S. 494, 503, where they are characterized as those liberties that are deeply rooted in this nation's history and tradition. ID, at 503. See also Griswold v. Connecticut, 381 U.S., at 506. It is obvious to us that neither of these formulations would extend a fundamental right to homosexuals to engage in acts of consensual sodomy. Proscriptions against that conduct have ancient roots. See generally Survey on the Constitutional Right to Privacy in the Context of Homosexual Activity, 40 U. Miami L. Rev. 521, 525. Sodomy was a criminal offense at common law and was forbidden by the laws of the original 13 states when they ratified the Bill of Rights. In 1868, when the 14th Amendment was. Criminal sodomy laws in effect in 1791, Connecticut, 1 Public Statute Laws of the State of Connecticut, 1808, Title LXVI, ch. 1, 2. Delaware, 1 Laws of the State of Delaware, 1797, ch. 22, 5. Georgia had no criminal sodomy statute until 1816, but sodomy was a crime at common law, and the General Assembly adopted the Common Law of England as the Law of Georgia in 1784. The first laws of the state of Georgia, pt. 1, p. 290. Maryland had no criminal sodomy statute in 1791. Maryland's Declaration of Rights, passed in 1776, however, stated that the inhabitants of Maryland are entitled to the Common Law of England, and sodomy was a crime at common law. 4 W. Swindler, Sources and Documents of United States Constitutions 372. Massachusetts, Acts and Laws passed by the General Court of Massachusetts, ch. 14, Act of March 3, 1785. New Hampshire passed its first sodomy statute in 1718. Acts and Laws of New Hampshire 1680 to 1726, p. 141. Sodomy was a crime at common law in New Jersey at the time of the ratification of the Bill of Rights. The state enacted its first criminal sodomy law 5 years later. Acts of the 20th General Assembly, March 18, 1796, CHDC, 7. New York, Laws of New York, ch. 21. Bowers v. Hardwick. 186. Opinion of the Court. Ratified, all but 5 of the 37 states in the Union had criminal sodomy laws. In fact, until 1961, all 50 states outlawed sodomy, and today, 24 states and the District of Columbia. At the time of ratification of the Bill of Rights, North Carolina had adopted the English statute of Henry VIII outlawing sodomy. See collection of the statutes of the Parliament of England in force in the state of North Carolina, ch. 17, p. 314. Pennsylvania, Laws of the 14th General Assembly of the Commonwealth of Pennsylvania, CHCLIV, 2. Rhode Island passed its first sodomy law in 1662. The earliest acts and laws of the colony of Rhode Island and Providence Plantation 1647 to 1719, p. 142. South Carolina, Public Laws of the State of South Carolina, p. 49. At the time of the ratification of the Bill of Rights, Virginia had no specific statute outlawing sodomy, but had adopted the English common law. 9 Hennings Laws of Virginia, ch. 5, 6, p. 127. Criminal sodomy statutes in effect in 1868, Alabama, Alla Rev Code 3604. Arizona, Howell Code, ch. 10, 48. Arkansas, Ark. Stat, ch. 51, Art. 4, 5. California, 1 Caloregen Laws, 1450, 48. Colorado, Colorado Rev Stat, ch. 22, 45, 46. Connecticut, Congen Stat, Title 122, ch. 7, 124. Continue to provide criminal penalties for sodomy performed in private and between consenting adults. See Survey, U Miami L Rev. Supra, at 524, N9. Against this background, to claim that a right to engage in such conduct is deeply rooted in this nation's history and tradition or implicit in the concept of ordered liberty is, at best, facetious. Nor are we inclined to take a more expansive view of our authority to discover new fundamental rights embedded in the Due Process Clause. The court is most vulnerable and comes nearest to illegitimacy when it deals with judge-made constitutional law having little or no cognizable roots in the language or design of the Constitution. That this is so was painfully demonstrated by the face-off between the executive and the court in the 1930s, which resulted in the repudiation. Nevada, Nevada Comp Laws, 1861 to 1900, Crimes and Punishments, 45. New Hampshire, N.H. Laws, Act. Of much of the substantive gloss that the court had placed on the due process clauses of the 5th and 14th Amendments. There should be, therefore, great resistance to expand the substantive reach of those clauses, particularly if it requires redefining the category of rights deemed to be fundamental. Otherwise, the judiciary necessarily takes to itself further authority to govern the country without express constitutional authority. The claimed right pressed on us today falls far short of overcoming this resistance. Respondent, however, asserts that the result should be different where the homosexual conduct occurs in the privacy of the home. He relies on Stanley v. Georgia, 394 U.S. 557, where the court held that the First Amendment prevents conviction for possessing and reading obscene material in the privacy of one's home, if the First Amendment means anything. It means that a state has no business telling a man, sitting alone in his house, what books he may read or what films he may watch. ID, at 565. Stanley did protect conduct that would not have been protected outside the home, and it partially prevented the enforcement of state obscenity laws, but the decision was firmly grounded in the First Amendment. The right pressed upon us here has no similar support in the text of the Constitution, and it does not qualify for recognition under the prevailing principles for construing the 14th Amendment. Its limits are also difficult to discern. Plainly enough, otherwise illegal conduct is not always immunized whenever it occurs in the home. Victimless crimes, such as the possession and use of illegal drugs, do not escape the law where they are committed at home. Stanley itself recognized that its holding offered no protection for the possession in the home of drugs, firearms, or stolen goods. ID, at 568, N11. And if respondent's submission is limited to the voluntary sexual conduct between consenting adults, it would be difficult, except by fiat, to limit the claimed right to homosexual conduct. October term, 1985. CJ, concurring. 478 U.S. While leaving exposed to prosecution adultery, incest, and other sexual crimes even though they are committed in the home. We are unwilling to start down that road. Even if the conduct at issue here is not a fundamental right. Respondent asserts that there must be a rational basis for the law and that there is none in this case other than the presumed belief of a majority of the electorate in Georgia that homosexual sodomy is immoral and unacceptable. This is said to be an inadequate rationale to support the law. The law, however, is constantly based on notions of morality, and if all laws representing essentially moral choices are to be invalidated under the Due Process Clause, the courts will be very busy indeed. Even respondent makes no such claim, but insists that majority sentiments about the morality of homosexuality should be declared inadequate. We do not agree, and are unpersuaded that the sodomy laws of some 25 states should be invalidated on this basis. Accordingly, the judgment of the Court of Appeals is reversed. Chief Justice Berger, concurring. I join the court's opinion, but I write separately to underscore my view that in constitutional terms there is no such thing as a fundamental right to commit homosexual sodomy. As the court notes, at 192, the proscriptions against sodomy have very ancient roots. Decisions of individuals relating to homosexual conduct have been subject to state intervention throughout the history of Western civilization. Condemnation of those practices is firmly rooted in Judeo-Christian moral and ethical standards. Homosexual sodomy was a capital crime under Roman law. See Code Theod. 9.7.6, Code Just. September 9, 31. See also D. Bailey, Homosexuality. Respondent does not defend a judgment below based on the Ninth Amendment, the Equal Protection Clause, or the Eighth Amendment. 186. J. Concurring. And the Western Christian Tradition 70-81. During the English Reformation, when powers of the ecclesiastical courts were transferred to the King's Courts, the first English statute criminalizing sodomy was passed. 25 Hen. 8, ch. 6. Blackstone described the infamous crime against nature as an offense of deeper malignity than rape, a heinous act the very mention of which is a disgrace to human nature, and a crime not fit to be named. 4 W. Blackstone, Commentaries *215. The common law of England, including its prohibition of sodomy, became the received law of Georgia and the other colonies. In 1816 the Georgia legislature passed the statute at issue here, and that statute has been continuously in force in one form or another since that time. To hold that the act of homosexual sodomy is somehow protected as a fundamental right would be to cast aside millennia of moral teaching. This is essentially not a question of personal preferences but rather of the legislative authority of the state. I find nothing in the Constitution depriving a state of the power to enact the statute challenged here. Concurring. I join the opinion of the court. I agree with the court that there is no fundamental right i.e., no substantive right under the Due Process Clause such as that claimed by Respondent Hardwick, and found to exist by the Court of Appeals. This is not to suggest, however, that Respondent may not be protected by the Eighth Amendment of the Constitution. The Georgia statute at issue in this case, GA Code N. 16-6-2, authorizes a court to imprison a person for up to 20 years for a single private, consensual act of sodomy. In my view, a prison sentence for such conduct, certainly a sentence of long duration, would create a serious Eighth Amendment issue. Under the Georgia statute, a single act of sodomy, even in the private setting of a home, is a October term, 1985. J. Concurring. 478 U.S. Felony comparable in terms of the possible sentence imposed to serious felonies such as aggravated battery, 16-5-24, first-degree arson, 16-7-60, and robbery, 16-8-40. 1. In this case, however, respondent has not been tried, much less convicted and sentenced. Moreover, respondent has not raised the Eighth Amendment issue below. For these reasons this constitutional argument is not before us. Among those states that continue to make sodomy a crime, Georgia authorizes one of the longest possible sentences. See Allah. Code 13A6-65, Arizona Rev. Stat and 13-1400 and it was conceded at oral argument that, prior to the complaint against Respondent Hardwick, there had been no reported decision involving prosecution for private homosexual sodomy under the statute for several decades. See Thompson v. Aldredge, 187 GA 467, 200 SE 799. Moreover, the state has declined to present the criminal charge against Hardwick to a grand jury, and this is a suit for declaratory judgment brought by respondents challenging the validity of the statute. The history of non-enforcement suggests the moribund character today of laws criminalizing this type of private, consensual conduct. Some 26 states have repealed similar statutes. But the constitutional validity of the Georgia statute was put in issue by respondents, and for the reasons stated by the court, I cannot say that conduct condemned for hundreds of years has now become a fundamental right. Bowers v. J. Dissenting. Blackman, with whom Tice Marshall, and Join, dissenting. This case is no more about a fundamental right to engage in homosexual sodomy, as the court purports to declare, ante, at 191, than Stanley v. Georgia, 394 U.S. 557, was about a fundamental right to watch obscene movies, or Katz v. United States. 389 U.S. 347, was about a fundamental right to place interstate bets from a telephone booth. Rather, this case is about the most comprehensive of rights and the right most valued by civilized men, namely, the right to be let alone. Olmstead v. United States, 277 U.S. 438, 478. The statute at issue, GA Code N 16-6-2, denies individuals the right to decide for themselves whether to engage in particular forms of private, consensual sexual activity. The court concludes that 16-6-2 is valid essentially of many conduct illegal and have done so for a very long time. Ante, at 190. But the fact that the moral judgments expressed by statutes like 16-6-2 may be natural and familiar ought not to conclude our judgment upon the question whether statutes embodying them conflict with the Constitution of the United States. Roe v. Wade, 410 U.S. 113, 117, quoting Lochner v. New York, 198 U.S. 45, 76. Like Justice Holmes, I believe that T is revolting to have no better reason for a rule of law than that so it was laid down in the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have vanished long since, and the rule simply persists from blind imitation of the past. Holmes, The Path of the Law, 10 Harv. L. Rev. 457, 469. I believe we must analyze Respondent Hardwick's claim in the light of the values that underlie the constitutional right to privacy. If that right means anything, it means that, before Georgia can prosecute its citizens for making choices about the most inti. October term, 1985. J. Dissenting. 478. Made aspects of their lives, it must do more than assert that the choice they have made is an abominable crime not fit to be named among Christians. Herring v. State, 119 GA 709, 721, 46 SE 876, 882. In its haste to reverse the Court of Appeals and hold that the Constitution does not confer a fundamental right upon homosexuals to engage in sodomy, ante, at 190. The court relegates the actual statute being challenged to a footnote and ignores the procedural posture of the case before it. A fair reading of the statute and of the complaint clearly reveals that the majority has distorted the question in this case. Presence. First, the court's almost obsessive focus on homosexual activity is particularly hard to justify in light of the broad language Georgia has used. Unlike the court, the Georgia legislature has not proceeded on the assumption that homosexuals are so different from other citizens that their lives may be controlled in a way that would not be tolerated if it limited the choices of those other citizens. Cf. ante, at 188, and 2. Rather, Georgia has provided that person commits the offense of sodomy when he performs or submits to any sexual act involving the sex organs of one person and the mouth or anus of another. GA Code N 16-6-2. The sex or status of the persons who engage in the act is irrelevant as a matter of state law. In fact, to the extent I can discern a legislative purpose for Georgia's 1968 enactment of 16-6-2, that purpose seems to have been to broaden the coverage of the law to reach heterosexual as well as homosexual activity. I therefore see no basis for the Georgia to find sodomy as the carnal knowledge and connection against the order of nature, by man with man, or in the same unnatural manner with woman. GACRIM Code 26-5901. In Thompson v. Aldredge, 187 GA 467, 200 SE 799, court's decision to treat this case as an as-applied challenge to 16-6-2, see ante, at 188, and 2, or for Georgia's attempt, both in its brief and at oral argument, to defend 16-6-2 solely on the grounds that it prohibits homosexual activity. Michael Hardwick's standing may rest in significant part on Georgia's apparent willingness to enforce against homosexuals a law it seems not to have any desire to enforce against heterosexuals. CTR of Oral ARG 4-5, cf 760 F2D 1202, 1205 to 1206. But his claim that 16-6-2 involves an unconstitutional intrusion into his privacy and his right of intimate association does not depend in any way on his sexual orientation. Second, I disagree with the court's refusal to consider whether 16-6-2 runs afoul of the 8th or 9th Amendments or the Equal Protection Clause of the 14th Amendment. Ante, at 196, n8. Respondent's complaint expressly invoked the 9th Amendment, see App. 6, and he relied heavily before this court on Griswold v. Connecticut, 381 U.S. 479, 484, which identifies that amendment as one of the specific constitutional provisions giving life and substance to our understanding of privacy. See brief for Respondent Hardwick 10-12, tr of Oral ARG 33. More importantly, the procedural posture of the case requires that we affirm the Court of Appeals judgment if there is any ground on which respondent may be entitled to relief. This case is before us on petitioner's motion to dismiss for failure to state a claim, Federal Rule Civ Proc 12. Cf 17. It is a well-settled principle of law that a complaint should not be dismissed merely because a plaintiff's allegations do not support the particular legal theory he advances. For the court is under a duty to examine the complaint to determine if the allegations provide for relief on any possible theory. Prohibit heterosexual statute currently the restrictive 16J Pub. Term, 1985. J. Dissenting. Thus, even if respondent did not advance claims based on the 8th or 9th Amendments, or on the Equal Protection Clause, his complaint should not be dismissed if any of those provisions could entitle him to relief. I need not reach either the 8th Amendment or the Equal Protection Clause issues because I believe that Hardwick has stated a cognizable claim that 16-6-2 interferes with constitutionally protected interests in privacy and freedom of intimate association. But neither the 8th Amendment nor the Equal Protection Clause is so clearly irrelevant that a claim resting on either provision should be peremptorily dismissed. The court's cramped reading of the In Robinson v. California, 370 U.S. 660, the court held that the 8th Amendment barred convicting a defendant due to his status as a narcotics addict. Since that condition was apparently an illness which may be contracted innocently or involuntarily. ID, at 667. In Powell v. Texas, 392 U.S. 514, where the court refused to extend Robinson to punishment of public drunkenness by a chronic alcoholic, one of the factors relied on by in writing the plurality opinion was that Texas had not attempted to regulate appellant's behavior in the privacy of his own home. ID, at 532. Wrote separately, analysis of this difficult case is not advanced by preoccupation with the label condition. In Robinson the court dealt with a statute which makes the status 666. By precluding criminal conviction for such a status the court was dealing with a condition brought about by acts remote in time from the application of the criminal sanctions contemplated, a condition which was relatively permanent in duration, and a condition of great magnitude and significance in terms of human behavior and values. If it were necessary to distinguish between acts and conditions for purposes of the 8th Amendment, I would adhere to the concept of condition implicit in Robinson volitional acts brought about the condition and whether those acts are suv. Bowers v. Hardwick. 186. J. Dissenting. Issue before it makes for a short opinion, but it does little to make for a persuasive one. 2. Our cases long have recognized that the Constitution embodies a promise that a certain private sphere of individual liberty will be kept largely beyond the reach of government. Thornburg v. American College of Obstetricians and Gynecologists, 476 U.S. 747, 772. In construing the right to privacy, the court has proceeded along two somewhat faciently proximate to the condition for it to be permissible to impose penal sanctions on the condition. ID, at 550 to 551, and 2. Despite historical views of homosexuality, it is no longer viewed by mental health professionals as a disease or disorder. See brief for American Psychological Association and American Public Health Association as Amici Curiae 8-11. But, obviously, neither is it simply a matter of deliberate personal election. Homosexual orientation may well form part of the very fiber of an individual's personality. Consequently, under Jew's analysis in Powell, the Eighth Amendment may pose a constitutional barrier to sending an individual to prison for acting on that attraction regardless of the circumstances. An individual's ability to make constitutionally protected decisions concerning sexual relations, Care v. Population Services International, 431 U.S. 678, 711. J. Concurring in part and concurring in judgment. Is rendered empty indeed if he or she is given no real choice but a life without any physical intimacy. With respect to the Equal Protection Clause's applicability to 16-6-2. I note that Georgia's exclusive stress before this court on its interest in prosecuting homosexual activity despite the gender-neutral terms of the statute may raise serious questions of discriminatory enforcement. Questions that cannot be disposed of before this court on a motion to dismiss. See Iqua v. Hopkins, 118 U.S. 356, 373-374. The legislature having decided that the sex of the participants is irrelevant to the legality of the acts, I do not see why the state can defend 16-6-2 on the ground that individuals singled out for prosecution are of the same sex as their partners. Thus, under the circumstances of this case, a claim under the Equal Protection Clause may well be available without having to reach the more controversial question whether homosexuals are a suspect class. See, e.g., Roland v. Mad River Local School District, 470 U.S. 1009. J. Descending from denial of certiorari, note, the constitutional status of sexual orientation, homosexuality as a suspect classification, 98 Harv. L. Rev. 1285. Term, 1985. J. Descending. 478 U.S. Tinct, albeit complementary, lines. First, it has recognized a privacy interest with reference to certain decisions that are properly for the individual to make. E.g., Roe v. Wade, 410 U.S. 113, Pierce v. Society of Sisters, 268 U.S. 510. Second, it has recognized a privacy interest with reference to certain places without regard for the particular activities in which the individuals who occupy them are engaged. E.g., United States v. Caro, 468 U.S. 705, Payton v. New York, 445 U.S. 573, Rios v. United States, 364 U.S. 253. The case before us implicates both the decisional and the spatial aspects of the right to privacy. A. The court concludes today that none of our prior cases dealing with various decisions that individuals are entitled to make free of governmental interference bears any resemblance to the claimed constitutional right of homosexuals to engage in acts of sodomy. That is asserted in this case. Ante, at 190 to 191. While it is true that these cases may be characterized by their connection to protection of the family, see Roberts v. United States J.C.'s, 468 U.S. 609, 619. The court's conclusion that they extend no further than this boundary ignores the warning in Moore v. East Cleveland, 431 U.S. 494, 501. Against clause our eyes to the basic reasons why certain rights associated with the family have been accorded shelter under the 14th Amendment's Due Process Clause. We protect those rights not because they contribute, in some direct and material way, to the general public welfare, but because they form so central a part of an individual's life. The concept of privacy embodies the moral fact that a person belongs to himself and not others nor to society as a whole. Thornburg v. American College of Obstetricians and Gynecologists, 476 U.S., at 777, and 5. J. Concurring, quoting Fried, Correspondence, 6 Philosophy and Pub Affairs 288 to 289. And so we protect the marry precisely because marriage is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Griswold v. Connecticut, 381 U.S., at 486. We protect the decision whether to have a child because parenthood alters so dramatically an individual's self-definition, not because of demographic considerations or the Bible's command to be fruitful and multiply. C. F. Thornburg v. American College of Obstetricians and Gynecologists, Supra, at 777, and 6. Concurring. And we protect the family because it contributes so powerfully to the happiness of individuals, not because of a preference for stereotypical households. Cf. Moore v. East Cleveland, 431 U.S., at 500 to 506. The court recognized in Roberts, 468 U.S., at 619, that the ability independently to define one's identity that is central to any concept of liberty cannot truly be exercised in a vacuum. We all depend on the emotional enrichment from close ties with others. Ibid. Only the most willful blindness could obscure the fact that sexual intimacy is a sensitive, key relationship of human existence, central to family life, community welfare, and the development of human personality. Paris Adult Theater IV Slayton, 413 US 49. 63, see also Care EV Population Services International, 431 US 678, 685. The fact that individuals define themselves in a significant way through their intimate sexual relationships with others suggests, in a nation as diverse as ours, that there may be many right ways of conducting those relationships. And that much of the richness of a relationship will come from the freedom an individual has to choose the form and nature of these intensely personal bonds. See Karst, The Freedom of Intimate Association, 89 Yale LJ 624, 600. In a variety of circumstances we have recognized that a necessary corollary of giving individuals freedom to choose October term, how to conduct their lives is acceptance of the fact that different individuals will make different choices. For example, in holding that the clearly important state interest in public education should give way to a competing claim by the Amish to the effect that extended formal schooling threatened their way of life, the court declared, there can be no assumption that today's majority is right and the Amish and others like them are wrong. A way of life that is odd or even erratic but interferes with no rights or interests of others is not to be condemned because it is different. Wisconsin v. Yoder, 406 U.S. 205, 200. The court claims that its decision today merely refuses to recognize a fundamental right to engage in homosexual sodomy. What the court really has refused to recognize is the fundamental interest all individuals have in controlling the nature of their intimate associations with others. B. The behavior for which Hardwick faces prosecution occurred in his own home, a place to which the Fourth Amendment attaches special significance. The court's treatment of this aspect of the case is symptomatic of its overall refusal to consider the broad principles that have informed our treatment of privacy in specific cases. Just as the right to privacy is more than a mere aggregation of a number of entitlements to engage in specific behavior, so too, protecting the physical integrity of the home is more than merely a means of protecting specific activities that often take place there. Even when our understanding of the contours of the right to privacy depends on reference to a place, Katz v. United States, 389 U.S., at 361. The essence of a Fourth Amendment violation is not the breaking of doors, and the rummaging of his drawers, but rather is the invasion of his infeasible right of personal security, personal liberty, and private property. California v. Cirillo, 400 and the court's interpretation of the pivotal case of Stanley v. Georgia, 394 U.S. 557, is entirely unconvincing. Stanley held that Georgia's undoubted power to punish the public distribution of constitutionally unprotected, obscene material did not permit the state to punish the private possession of such material. According to the majority here, Stanley relied entirely on the First Amendment, and thus, it is claimed, sheds no light on cases not involving printed materials. Ante, at 195. But that is not what Stanley said. Rather, the Stanley Court anchored its holding in the Fourth Amendment's special protection for the individual in his home. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. These are the rights that appellant is asserting in the case before us. He is asserting the right to read or observe what he pleases, the right to satisfy his intellectual and emotional needs in the privacy of his own home. 394 U.S., at 500. The central place that Stanley gives Justice Brandeis' dissent in Olmsted, a case raising no First Amendment claim, shows that Stanley rested as much on the court's understanding of the Fourth Amendment as it did on the First. Indeed, in Paris Adult Theater IV Slayton, 413 U.S. 49, the court suggested that reliance on the Fourth October term, 1985, amendment not only supported the court's outcome in Stanley but actually was necessary to it, if obscene material unprotected by the First Amendment in itself carried with it a penumbra of constitutionally protected privacy. This court would not have found it necessary to decide Stanley on the narrow basis of the privacy of the home, which was hardly more than a reaffirmation that a man's home is his castle. 413 U.S., at 66. The right of the people to be secure in their houses, expressly guaranteed by the Fourth Amendment, is perhaps the most textual of the various constitutional provisions that inform our understanding of the right to privacy. And thus I cannot agree with the court's statement that he right pressed upon us here has no support in the text of the Constitution, ante, at 195. Indeed, the right of an individual to conduct intimate relationships in the intimacy of his or her own home seems to me to be the heart of the Constitution's protection of privacy. 3. The court's failure to comprehend the magnitude of the liberty interests at stake in this case leads it to slight the question whether petitioner, on behalf of the state, has justified George's infringement on these interests. I believe that neither of the two general justifications for 16-6-2 that petitioner has advanced warrants dismissing respondent's challenge for failure to state a claim. First, petitioner asserts that the acts made criminal by the statute may have serious adverse consequences for the general public health and welfare, such as spreading communicable diseases or fostering other criminal activity. Brief for petitioner 37. Inasmuch as this case was dismissed by the district court on the pleadings, it is not surprising that the record before us is barren of any evidence to support petitioner's claim. In light of the state of the record, I challenge to 16-6-2 were to apply simple scrutiny to the statute, Georgia. Bowers v. Hardwick. 186. J. Dissenting. No justification for the court's attempt to equate the private, consensual sexual activity at issue here with the possession in the home of drugs, firearms, or stolen goods, ante, at 195, to which Stanley refused to extend its protection. 394 U.S., at 568, and 11. None of the behavior so mentioned in Stanley can properly be viewed as victimless, ante, at 195, drugs and weapons are inherently dangerous, c. e.g., McLaughlin v. United States, 476 U.S. 16, and for property to be stolen. Someone must have been wrongfully deprived of it. Nothing in the record before the court provides any justification for finding the activity forbidden by 16-6-2 to be physically dangerous, either to the persons engaged in it or to others. An actual connection between the forbidden acts and the ill effects it seeks to prevent. The connection between the acts prohibited by 16-6-2 and the harms identified by petitioner in his brief before this court is a subject of hot dispute, hardly amenable to dismissal under Federal Rule of Civil Procedure 12. Compare, e.g., brief for petitioner 36-37 and brief for David Robinson, Jr. As amicus curiae 23-28, on the one hand, with People v. Onofre, 51 NY2D 476, 489, 415 and although I do not think it necessary to decide today issues that are not even remotely before us, it does seem to me that a court could find simple, analytically sound distinctions between certain private, consensual sexual conduct, on the one hand, and adultery and incest, on the other. For example, marriage, in addition to its spiritual aspects, is a civil contract that entitles the contracting parties to a variety of governmentally provided benefits. A state might define the contractual commitment necessary to become eligible for these benefits to include a commitment of fidelity and then punish individuals for breaching that contract. Moreover, a state might conclude that adultery is likely to injure third persons, in particular, spouses and children of persons who engage in extramarital affairs. With respect to incest, a court might well agree with respondent that the nature of familial relationships renders true consent to incestuous activity sufficiently problematical that a blanket prohibition of such activity. October term. The core of petitioner's defense of 16-6-2, however, is that respondent and others who engage in the conduct prohibited by 16-6-2 interfere with Georgia's exercise of the right of the nation and of the states to maintain a decent society. Paris Adult Theater IV Slayton, 413 U.S., at 59-60, quoting Jacob Ellis v. Ohio, 378 U.S. 184, 199. Essentially, petitioner argues, and the court agrees, that the fact that the acts described in 16-6-2 for hundreds of years, if not thousands, have been uniformly condemned as immoral is a sufficient reason to permit a state to ban them today. Brief for petitioner 19, see ante, at 190. I cannot agree that either the length of time a majority has held its convictions or the passions with which it defends them can withdraw legislation from this court's scrutiny. See, e.g., Roe v. Wade, 410 U.S. 113, Loving v. Virginia, is warranted. CTR of Oral ARG 21-22. Notably, the court makes no effort to explain why it has chosen to group private, consensual homosexual activity with adultery and incest rather than with private, consensual heterosexual activity by unmarried persons or, indeed, with oral or anal sex within marriage. The parallel between Loving and this case is almost uncanny. There, too, the state relied on a religious justification for its law. Compare 388 U.S., at 3, with brief for petitioner 20 to 21. There, too, defenders of the challenged statute relied heavily. Compare 388 U.S., at 3, with brief for petitioner 20 to 21. There, too, defenders of the challenged statute relied heavily on the fact that when the 14th Amendment was ratified, most of the states had similar prohibitions. Compare brief for appellee in Loving. The parallel between Loving and this case is almost uncanny. There, too, the state relied on a religious justification for its law. Compare 388 U.S., at 3, quoting trial court statement that Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. The fact that he separated the races shows that he did not intend for the races to mix, with brief for petitioner 20 to 21, relying on the Old and New Testaments and the writings of Saint Thomas Aquinas to show that traditional Judeo-Christian values proscribe such conduct. There, too, defenders of the challenged statute relied. There, too, defenders of the challenged statute relied heavily on the fact that when the 14th Amendment was ratified, most of the states had similar prohibitions. Compare brief for appellee in Loving v. Virginia, 0. T. 1966, number 395, pp. 28 to 29, with ante, at 192 to 194, and n6. There, too, at the time the case came before the court, many of the states still had criminal statutes concerning the conduct at issue. Compare 388 U.S., at 6, and 5, with ante, at 193 to 194, noting that 24 states and the District of Columbia have sodomy. V. Hardwick. 186. J. Dissenting. For the Court in West Virginia Board of Education v. Barnett, 319 U.S. 624, 641 to 642. We apply the limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse or even contrary will disintegrate the social organization. Freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. For the court in West Virginia, Board of Education v. Barnett, 319 U.S. 624, 641 to 642. We apply the limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse or even contrary will disintegrate the social organization. Freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. See also Karst, 89 Yale LJ, at 627. It is precisely because the issue raised by this case touches the heart of what makes individuals what they are that we should be especially sensitive to the rights of those whose choices upset the majority. The assertion that traditional Judeo-Christian values proscribe the conduct involved, brief for petitioner 20, cannot provide an adequate justification for 16-6-2. That's certain, but by no means all. Religious groups condemn the behavior at issue gives the state no license to impose their judgments on the entire citizenry. The legitimacy of secular legislation depends instead on whether the state can advance some justification for its law beyond its conformity to religious doctrine. See, e.g., McGowan v. Maryland, 366 U.S. 420, 429 to 453, Stone v. Graham, 449 U.S. 39. Thus, far from buttressing his case, petitioner's invocation of Leviticus, Romans, St. Thomas Aquinas, and sodomy's heretical status during the Middle Ages undermines his suggestion that 16-6-2 represents a legitimate use of secular coercive power. A state can no more punish private behavior b. statutes. Yet the court held, not only that the invidious racism genius law violated the Equal Protection Clause, c. 388 U.S., at 7-12. Deprived the lovings of due process by denying them to marry that had long been recognized as one personal rights essential to the orderly pursuit of happiness by free men. Id. At origin of Anglo-American anti-sodomy statutes is patent. It was not until 1533 that sodomy was made a 25 hen. 8, ch. 6. Origin of Anglo-American anti-sodomy statutes is patent. It was not until 1533 that sodomy was made a 25 hen. 8, ch. 6. Until that time, the offense. October term, 1985. J. Dissenting. Cause of religious intolerance. Then it can punish such behavior because of racial animus. The Constitution cannot control such prejudices, but neither can it tolerate them. Private biases may be outside the reach of the law, but the law cannot, directly or indirectly, give them effect. Palmore v. Sidoti, 466 U.S. 429, 433. No matter how uncomfortable a certain group may make the majority of this court, we have held that public intolerance or animosity cannot constitutionally justify the deprivation of a person's physical liberty. O'Connor v. Donaldson, 422 U.S. 563, 575. Nor can 16-6-2 be justified as a morally neutral exercise of Georgia's power to protect the public environment, Paris Adult Theatre I, 413 U.S., at 68-69. Certainly, some private behavior can affect the fabric of society as a whole. Reasonable people may differ about whether particular sexual acts are moral or immoral, but we have ample evidence for believing that people will not abandon morality, will not think any better of murder, cruelty, and dishonesty, merely because some private sexual practice which they abominate is not punished by the law. H.L.A. Hart, Immorality and Treason, reprinted in the Law as Literature 220, 225. Petitioner and the court fail to see the difference between laws that protect public sensibilities and those that enforce private morality. Statutes banning was, in Sir James Stephen's words, merely ecclesiastical. Law of England 429 to 430. Pollock and Maitland similarly observed that he crime connected with heresy that the Vulgar History of English Law 554. The transfer of jurisdiction over prosecutions for sodomy to secular courts. The alteration of ecclesiastical jurisdiction attendant on England's break with the Roman Catholic interest in preventing or punishing involved. Cf. 6 Ecoke, Institutes. Bowers v. Hardwick. 186. J. Dissenting. Public sexual activity are entirely consistent with protecting the individual's liberty interest in decisions concerning sexual relations. The same recognition that those decisions are intensely private which justifies protecting them from governmental interference can justify protecting individuals from unwilling exposure to the sexual activities of others. But the mere fact that intimate behavior may be punished when it takes place in public cannot dictate how states can regulate intimate behavior that occurs in intimate places. See Paris Adult Theater I, 413 U.S., at 66, and 13. This case involves no real interference with the rights of others, for the mere knowledge that other individuals do not adhere to one's value system cannot be a legally cognizable interest, cf. Diamond v. Charles, 476 U.S. 54, 65-66, let alone an interest that can justify invading the houses, hearts, and minds of citizens who choose to live their lives differently. 4. It took but 3 years for the court to see the error in its analysis in Minersville School District v. Gobitis, 310 U.S. At oral argument a suggestion appeared that, while the Fourth Amendment's special protection of the home might prevent the state from enforcing 16-6-2 against individuals who engage in consensual sexual activity there, that protection would not make the statute invalid. CTR of Oral ARG 10-11. The suggestion misses the point entirely. If the law is not invalid, then the police can invade the home to enforce it, provided, of course, that they obtain a determination of probable cause from a neutral magistrate. One of the reasons for the court's holding in Griswold v. Connecticut, 381 U.S. 479, was precisely the possibility, and repugnancy, of permitting searches to obtain evidence regarding the use of contraceptives. ID, at 485-486. Permitting the kinds of searches that might be necessary to obtain evidence of the sexual activity banned by 16-6-2 seems no less intrusive, or repugnant. Cf. Winston v. Lee, 470 U.S. 753, Mary Beth G. v. City of Chicago, 723 F2D 1263, 1274. October term, 1985. J. Dissenting. 478 U.S. 586, and to recognize that the threat to national cohesion posed by a refusal to salute the flag was vastly outweighed by the threat to those same values posed by compelling such a salute. See West Virginia Board of Education v. Barnett, 319 U.S. 624. I can only hope that here, too, the court soon will reconsider its analysis and conclude that depriving individuals of the right to choose for themselves how to conduct their intimate relationships poses a far greater threat to the values most deeply rooted in our nation's history than tolerance of nonconformity could ever do. Because I think the court today betrays those values, I dissent. Justice Stevens, with whom Justice Brennan and Justice Marshall join, dissenting. Like the statute that is challenged in this case, the rationale of the court's opinion applies equally to the prohibited conduct regardless of whether the parties who engage in it are married or unmarried, or are of the same or different sexes. Sodomy was condemned as an odious and sinful type of behavior during the formative period of the common law. ICGA Code N 16-6-2. Court states that the issue presented is whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time. Ante, at 190. In reality, however, it is the indiscriminate prohibition of sodomy, heterosexual as well as homosexual, that has been present for a very long time. CNN 3, 4, and 5, infra. Moreover, the reasoning the court employs would provide the same support for the statute as it is written as it does for the statute as it is narrowly construed by the court. IC, e.g., 1 W. Hawkins, Pleas of the Crown 9, all unnatural carnal copulations, whether with man or beast, seem to come under the notion of sodomy, which was felony by the antient common law, and punished, according to some authors, with burning, according to others. With burying alive, 4 W. Blackstone, Commentaries *215. Bowers v. Hardwick. 186. J. Dissenting. That condemnation was equally damning for heterosexual and homosexual sodomy. Moreover, it provided no special exemption for married couples. The license to cohabit and to produce legitimate offspring simply did not include any permission to engage in sexual conduct that was considered a crime against nature. The history of the Georgia statute before us clearly reveals this traditional prohibition of heterosexual, as well as homosexual, sodomy. Indeed, at one point in the 20th century, Georgia's law was construed to permit certain sexual conduct between homosexual women even though such conduct was prohibited between heterosexuals. The history of the statute cited by the majority as proof for the proposition that sodomy is not constitutionally protected, ante, at 192 to 194. C1e East, Pleas of the Crown 480, J. Hawley and M. McGregor, The Criminal Law 287, 3d ed. 1899. I. C. J. May, The Law of Crimes 203, Sodomy, otherwise called buggery, bestiality, and the crime against nature, is the unnatural copulation of two persons with each other, or of a human being by a man with a man, by a man with a beast, or by a woman with a beast, or by a man with a woman his wife, in which case, if she consent, she is an accomplice. I. The predecessor of the current Georgia statute provided, sodomy is the carnal knowledge and connection against the order of nature, by man with man, or in the same unnatural manner with woman. G.A. Code, Tit. 1, pt 4, 4251. This prohibition of heterosexual sodomy was not purely hortatory. See, e.g., Comer v. State, 21 Ga Ap 306, 94 Se 314. And NN 5 and 6, similarly reveals a prohibition on heterosexual, as well as homosexual, sodomy. Because the Georgia statute expresses the traditional view that sodomy is an immoral kind of conduct regardless of the identity of the persons who engage in it, I believe that a proper analysis of its constitutionality requires consideration of two questions. First, may a state totally prohibit the described conduct by means of a neutral law applying without exception to all persons subject to its jurisdiction? If not, may the state save the statute by announcing that it will only enforce the law against homosexuals? The two questions merit separate discussion. Our prior cases make two propositions abundantly clear. First, the fact that the governing majority in a state has traditionally viewed a particular practice as immoral is not a sufficient reason for upholding a law prohibiting the practice. Neither history nor tradition could save a law prohibiting miscegenation from constitutional attack. Second, individual decisions by married persons, concerning the intimacies of their physical relationship, even when not intended to produce offspring, are a form of liberty protected by the Due Process Clause of the 14th Amendment. Griswold v. Connecticut, 381 U.S. 479. Moreover, this protection extends to intimate choices by unmarried as well as married persons. Carey v. Population Services International, 431 U.S. 678, Eisenstadt v. Baird, 405 U.S. 438. Vast majority homosexual and heterosexual sodomy. Once treated as a crime. Similar law, at 287. Bowers v. Hardwick. J. Dissenting. In consideration of claims of this kind, the court has emphasized the individual interest in privacy, but its decisions have actually been animated by an even more fundamental concern. As I wrote some years ago, these cases do NBT deal with the individual's interest in protection from unwarranted public attention, comment, or exploitation. They deal, rather, with the individual's right to make certain unusually important decisions that will affect his own, or his family's, destiny. The court has referred to such decisions as implicating basic values, as being fundamental, and as being dignified by history and tradition. The character of the court's language in these cases brings to mind the origins of the American heritage of freedom, the abiding interest in individual liberty that makes certain state intrusions on the citizen's right to decide how he will live his own life intolerable. Guided by history, our tradition of respect for the dignity of individual choice in matters of conscience and the restraints implicit in the federal system. Federal judges have accepted the responsibility for recognition and protection of these rights in appropriate cases. Fitzgerald v. Porter Memorial Hospital, 523 F2D 716, 719 to 720, cert. Denied, 425 U.S. 916. Society has every right to encourage its individual members to follow particular traditions in expressing affection for one another and in gratifying their personal desires. It, of course, may prohibit an individual from imposing his will on another to satisfy his own selfish interests. It also may prevent an individual from interfering with, or violating, a legally sanctioned and protected relationship, such as marriage. And it may explain the relative advantages and disadvantages of different forms of intimate expression. But when individual married couples are isolated from observation by others, the way in which they voluntarily choose to conduct their intimate relations is a matter for them, not the state to decide. The essential liberty that animated the development of the law in cases like Griswold, Eisenstadt, and Carey surely embraces the right to engage in non-reproductive, sexual conduct that others may consider offensive or immoral. Paradoxical as it may seem, our prior cases thus establish that a state may not prohibit sodomy within the sacred precincts of marital bedrooms, Griswold, 381 U.S., at 485, or, indeed, between unmarried heterosexual adults. Eisenstadt, 405 U.S., at 453. In all events, it is perfectly clear that the state of Georgia may not totally prohibit the conduct proscribed by 16-6-2 of the Georgia Criminal Code. 2. If the Georgia statute cannot be enforced as it is written, if the conduct it seeks to prohibit is a protected form of liberty for the vast majority of Georgia citizens, the state must assume the burden of justifying a selective application of its law. Either the persons to whom Georgia seeks to apply its statute do not have the same interest in liberty that others have, or there must be a reason why the state may be permitted to apply a generally applicable law to certain persons that it does not apply to others. The first possibility is plainly unacceptable. Although the meaning of the principle that all men are created equal is not always clear, it surely must mean that every free citizen has the same interest in liberty that the members of the majority share. From the standpoint of the individual, the homosexual and the heterosexual have the same interest in deciding how he will live his own life, and, more narrowly, how he will conduct himself in his personal and voluntary unconstitutional couple would unconstitutional significantly, v. Hardwick. J. Dissenting associations with his companions. State intrusion into the private conduct of either is equally burdensome. The second possibility is similarly unacceptable. A policy of selective application must be supported by a neutral and legitimate interest, more substantial than a habitual dislike for, or ignorance about, the disfavored group. Neither the state nor the court has identified any such interest in this case. The court has posited as a justification for the Georgia statute the presumed belief of a majority of the electorate in Georgia that homosexual sodomy is immoral and unacceptable. Ante, at 196. But the Georgia electorate has expressed no such belief. Instead, its representatives enacted a law that presumably reflects the belief that all sodomy is immoral and unacceptable. Unless the court is prepared to conclude that such a law is constitutional, it may not rely on the work product of the Georgia legislature to support its holding. For the Georgia statute does not single out homosexuals as a separate class meriting special disfavored treatment. Nor, indeed, does the Georgia prosecutor even believe that all homosexuals who violate this statute should be punished. This conclusion is evident from the fact that the respondent in this very case has formally acknowledged in his complaint and in court that he has engaged, and intends to continue to engage, in the prohibited conduct. Yet the state has elected not to process criminal charges against him. As Powell points out, moreover, Georgia's prohibition on private, consensual sodomy has not been enforced for decades. The record of non-enforcement, in this case and in the last several decades, belies the Attorney General's representative. At 198, and 2, noting, Inchon about prosecution case I can recall was October term, 1985. Shins about the importance of the state's selective application of its generally applicable law. 2. Both Georgia statute and the Georgia prosecutor thus completely fail to provide the court with any support for the conclusion that homosexual sodomy, simpliciter, is considered unacceptable conduct in that state, and that the burden of justifying a selective application of the generally applicable law has been met. 3. The court orders the dismissal of respondent's complaint even though the state statute prohibits all sodomy, even though that prohibition is concededly unconstitutional with respect to heterosexuals, and even though the state's post hoc explanations for selective application are belied by the state's own actions. At the very least, I think it clear at this early stage of the litigation that respondent has alleged a constitutional claim sufficient to withstand a motion to dismiss, to I respectfully dissent. It is, of course, possible to argue that a statute has a purely symbolic role. Cf. Carey v. Population Services International, 431 U.S. 678, 715. And 3. Concurring in part and concurring in judgment. Since the Georgia Attorney General does not even defend the statute as written, however, CN 10, supra, the state cannot possibly rest on the notion that the statute may be defended for its symbolic message. Indeed, at this stage, it appears that the statute indiscriminately authorizes a policy of selective prosecution that is neither limited to the class of homosexual persons nor embraces all persons in that class. but rather applies to those who may be arbitrarily selected by the prosecutor for reasons that are not revealed either in the record of this case or in the text of the statute. If that is true, although the text of the statute is clear enough, its true meaning may be so intolerably vague that even-handed enforcement of the law is a virtual impossibility. Marks v. United States, 430 U.S. 188, 198. Concurring in part and dissenting in part.